Item number on, SSC 16 of 24.
This matter, my instance, yesterday.
Your name has not gone down. You appeared on whose behalf? State respondents. Who are those respondents? Lieutenant Governor, Lieutenant Governor was represented by you. Very well. You represented Lieutenant Governor, then Chief Secretary, Andaman Nicobar Administration, Deputy Commissioner, Nicobar District, Assistant Commissioner, Tehsildar, and Pradhan not. So 1 to 6. A matter has come up in the list under the heading to be mentioned, capital quote unquote, on being mentioned by the learned advocate who represented respondent numbers 1 to 6. Stop. 1 to 6, not stop. 1 to 6 for correction of the order dated 5th February 2025. Next paragraph. Inadvertently, in the cause title of the order dated 5th February 2025, name of Miss MS Bobita Das, learned advocate who represented respondent numbers 1 to 6 was not transcribed, though she appeared on behalf of those respondents. Next paragraph. Department is directed to incorporate name of Miss Bobita Das, learned advocate, in the cause title of the order dated 5th February 2025, who represented on behalf of respondent numbers 1 to 6. Stop. Next paragraph. This order forms part of the order dated 5th February 2025.
We are on NDPS 16 of 2025.
I was the respondent.
Case diary.
Teacher.
Recovery.
It is 45 and 10 grams. 2 grams.
Where is the recovery? CDR.
That is petitioner's name, the flag, procedure.
Flag.
Flag.
Name of the petitioner in the flag.
Flag.
Just a minute.
Page number.
Shahid
Page number 73 and 74.
Yes, Caesar.
5 grams made MP tamine.
Page number 73 and 74. Section P4.
Commercial quantity.
No, Lord. I will satisfy this one regarding the same.
Easy.
First Caesar 45.
45 grams.
Second Caesar 10 grams. For same person.
Easy.
First Caesar.
45. If it is 45 grams, then it is
First Caesar 45. During investigation.
10 gram.
Caesar,
Second Caesar.
10 grams.
So commercial, it is commercial quantity.
The quantity is more than 50 grams. So tiny everything. The 45 grams Caesar is from the position of the accused petitioner hearing, in which section 50 was applied. Lordship, in NDPS Act, section 50 is mandatory. In the second Caesar, it was after 2 days and it was from the house.
What about financial transactions? Chain of transactions.
You
You are renewing your prayer. Previously, your petition, your bail application was rejected by the coordinate bench. Yes.
13 December. 13 December, it was rejected. The London PP has assured us that they will be filing a supplementary charge.
When you are filing supplementary charge sheet.
It's 13 December 2020. Last order. After this order.
It cannot be bifurcated 10 plus 45.
No. So kindly appreciate. If section 50 is not compliant, then that Caesar cannot be saved from my first position loss. And the commercial quantity starts from 50. I am based inside intermediate quantity law. Can you appreciate that? If section 50 is not followed and the seizure of 10 gram is cannot be said. It needs to be proved in the trial. But kindly appreciate that 10 gram was seized from a house after 2 days. And when I was already in custody.
Yeah, last order.
It's not required. It's not required.
Lordship, Lordship.
Uh,
I think there is one judgment, Lordship. Lordship, kindly, Lordship. Lordship, kindly, one judgment, Lordship.
An application for bail under section 483 of Bharatiya Nagarik Suraksha Samhita in connection with FIR number 62 of 2024 dated 27th April 2024, PS Crime and Economic Offense within bracket CCS close bracket under section 22 within bracket B slash 22 within bracket C slash 29 of NDPS Act 1985. Next paragraph. It's a heading, cost title. Learned advocate representing the petitioner renews prayer for bail. Next paragraph. It is submitted that petitioner is in custody for more than 280 days and preliminary charge sheet has been filed. Stop. It is further submitted that first recovery was for 45 grams of psychotropic substance, and subsequently there was a recovery of 10 grams. Therefore, it should not be considered as a seizure of commercial quantity from the petitioner as alleged. Stop. Next paragraph. Learned advocate representing the state respondent. State representing the state has opposed the prayer for bail, and it is submitted that previously a coordinate bench has rejected bail application on 13 December 2024. Stop. Case diary has been produced in order to substantiate that alleged recovery is more than commercial quantity. Next paragraph. We have perused the materials available on record and examined the case diary, wherefrom it appears prima facie that there is an involvement of commercial quantity. Stop. Next paragraph. Considering the rigor considering the rigor of section 37 of NDPS Act 1985, we are inclined to reject the bail application. Stop. Hence, the application being CRM DV 14 of being CRM 3 CRM NDPS 3 of 2025 stands rejected. Add a line that the CD is returned to the learned advocate representing state. Sorry. Yes. That you have always. Stephen.
Yes.
Now you have annexed the order dated 10 January 2024. Just one. How this 10 January 2024 order is relevant? It is with regard to the representation which can be made on behalf of the petitioner by an advocate to be appointed by legal services authority. Yes, that I've seen the order.
I'm not acting on this for some reason. That is why the.
Now petitioner is appearing in person. What is the matter about? Yes.
They are using basically transport department is using unfit persons with cancelled registration. So they don't have insurance anything for public transport. All accident happens to the Maya, you do support life is wrong. So because this road, you know, this is not this state road like main road. There is not road in the heavy vehicles. So what happens is the accident occurred. And you only person died 14 years. So the individual who died from such as cancelled registration, no fitness and all. This is an absolutely wrong decision by the administration.
Now, therefore, we shall conclude that since there was no fitness certificate or there was no insurance, the accident occurred.
The passenger vehicles run without fitness. This is because you can't use
Accident occurred due to error of judgment
brake failure.
at a particular moment.
The brake failed because the fitness is not there. The 40, 50 year old buses cannot fly on the road.
There is a report, expert report.
The safety of the
No
passenger.
direction for any affidavit or report pilot, we can file affidavit of.
File your affidavit.
I need to operate,
Because issue is serious. If unfit buses are permitted to be permitted to ply, then that may cause loss of public life and that and damage of the properties. So why then how the damage the unfit buses why are being allowed to fly? That is the crux of the issue. Now, in addition, there two petitioners prayed for appointment of essential supporting staff. So you respond to this
Yes.
to these points agitated by the petitioner by presenting this public interest litigation by filing an affidavit.
Yes.
Record an order. Yes, yes.
Because That is the way we should that not to apply any vehicle until give consent without fitness certificate, without very.
At this stage, unless and until we
Let-
we satisfy our conscience,
Yes,
we cannot pass such order.
yes,
Try to appreciate our predicament. Because we have to satisfy our conscience that you have been able to make out a prima facie case which requires interim protection in order to protect the public life and property. So therefore, in order to find out whether you have been able to make out a prima facie case, their response is required to be considered. Matter is heard when a petitioner appears in person and respondents are represented by learned advocates. Stop. In terms of the previous order, a supplementary affidavit has been filed in closing order dated 10 January 2024, passed by a coordinate bench on a writ petition being WPA 7 of 2024. Stop. Stop. Supplementary affidavit is taken on record. Next paragraph. Petitioner has agitated before this court in connection with the present public interest litigation that the authority is allowing license holders to ply their unfit vehicles, to ply their license holders / vehicle operators to ply their unfit vehicles that may cause loss of life and public property. Stop. Considering the issue raised in this writ petition, we find it fit to direct the respondent authorities to file affidavit in opposition by 2 weeks, by 4 weeks from date, and affidavit in reply thereto, if any, be filed by 2 weeks, thereafter. Next paragraph. List the matter under the same heading before next available circuit after the time fixed herein above for exchanging affidavits. Yes, I have directed respondents. Yes.
Item number 4, we have the petition of 2024, and we have made the necessary correction to include the included respondent numbers 3 and 4, my lord, the first item. Why not this matter is required to be heard, my lord, or after paper posting?
What I am on, my lord, my land has filed an application for consolidation of this.
That may be allowed, that has already been allowed.
but two application is appearing on in the list. They can say can one and can two.
Sorry, the application is not responded to, but in the appeal section, by application in the state application, there is no reflection, there is no. The certain various parties.
Two application.
Advocate representing the court.
Why they delay? Both the applications are pending.
Yes, my lord, delayed will be controlled, my lord, 37 days.
The cost statement company number 5, section 10. And state application with 6 February 25. And look at the company. So, they propose on the cost statement. And the state application 6 February 25. And look at the statement. And the state application with 6 February 25.
Oh, that matter.
Now, the two unions were excluded, excluded in the array of respondents. There was an leave granted to amend the cost title that was not amended, or that was amended, but the copy of the amended cost title was
not
amended.
We were there in the writ petition as the added respondents, but in the appeal, they were not brought in. That leave was granted.
So that has been done. Let us see.
I got granted.
Leave to amend. just
But my God, I have tried to copy of the amended cost letter to my land. How my land.
76 days delay. Let the delay be condoned, allowing this application. And
Find the application. Yes, let it be allowed. We have to.
this is their appeal. Yes.
Is there any scope for passing
Uh,
interim order?
The paper book we filed and presented.
Due to application.
Application being Can 1 of 2024. Now, first record an order. In terms of the order dated 27 January 2025. Cost title of the memorandum of appeal you have amended and section 5 and stay. Cost title of memorandum of appeal, comma, section 5 application and stay application has been amended, thereby impleading two auto unions who are parties to the writ petition. Who are parties to the writ petition, who are parties to the connected writ petition. Stop. Next paragraph. Can 1 of 2024, the application being Can 1 of 2024 is for condonation of delay in presenting appeal. Stop. Next paragraph, we have perused the explanation offered in the application, and we express our satisfaction that petitioner was prevented by sufficient cause to from presenting the appeal within the statutory period of limitation. Stop. Next paragraph. Learned advocates representing the respondents submits that respondents have no objection if delay occurred in presenting the appeal is condoned. Next paragraph. Hence, the application being Can 1 of 2024 is allowed and delay occurred in presenting the appeal is condoned. Stop. Let the appeal be registered if it is otherwise in form. Before that, indicate a stay application number. Can 2 of 2024. Let the appeal be registered if it is otherwise in form. Stop. There is no scope for passing any interim order in the stay application. There is no scope for passing any interim order. Stop. Appeal is admitted. Stop. Learned advocate representing the appellants is directed to file in informal paper book in requisite number by 4 weeks. Stop. After filing of paper books by 1 week thereafter, same shall be served upon the learned advocates representing the respondents by 7 days. Next paragraph. Let the appeal be listed under the heading hearing before the next available bench after filing of paper book.
And 2 is disposed.
Right. Can 2 of 2024 stands disposed of. Yes. Yes.
Okay. 29 of 125.
Yes.
Forfeited appeal, I would say. Because there is a delay.
Let the matter be placed. Next, the time of call when the door of the government is paid for accommodation. There's a delay.
Yes.
the section 5 application taken out,
It's within time.
let her demonstrate.
No, it's not, there is no report of delay by the stamp reporter.
As staring in the face.
Yes, yes, please place your case. Yes. 7 November 2024.
24.
December 2024. You belated calculate করছো কি? আচ্ছা।
There may be the time which is exceeded, has been taken or taking delivery of the certified copy.
30 days statutory. period for
Statutory 17 order was passed.
7th of November.
7th of November. It should have been filed within
Here in
7th.
February, here in February.
No, it was filed in the, it was filed on 23rd December 2024.
2025 appeal, not to see. That is 2025.
It's filed from December.
When it was filed? it was filed on 23rd December 2024. Hey, what is the system here? What is the date of filing? This one or that one? But the stamp reporter doesn't say it is time barred petition.
On the very same date, the some.
23rd December.
December 2024.
And-
How it was registered as MAT 9 of 2025?
7 November 2024, order was passed, and appeal was preferred on 23rd December 2024. And that time which was consumed for obtaining certified copy should be excluded.
Even for that, section 5 is.
No.
Oh, Mr. Joypal, they are saying that after 23rd December, there were
No,
holiday. And since there was a holiday, the
That's why the number was given.
assigned to the.
Yes.
It should not be. Office is not, should not be. So when you have accepted.
Time for obtaining certified copy is to be excluded, Mr. Jayapal. That is the rule. That is our rule. So if the time for excluding the certified copy is obtaining certified copy is excluded, then it was a date for application of a copy on 17th December and it was obtained on 20th December. On 23rd December, it was filed.
See, the date of filing in the online is 16 January. They could have signed it, but filing was.
No, that was registered in 15 January. But it was filed on 23rd December. Yes, please take your case. Enough is enough. Yes. Stay application. Yes. First, place the order. Place the order.
The audit woman.
Wait, for the order.
47. That's school line
Village.
village.
Near airport at Port Blair.
Yes.
Land sold by their predecessor father. The petitioners claim that they are paying land revenue for the said land for some substantial period of time. Several rounds of litigation have occurred against the Deputy Commissioner of South Andaman and several directions have been issued by various benches of this court, inter alia in WP number such and such, dated such and such, in MAT number such and such, in WP number such and such, and dated such and such. Against each of the enlisted orders, the Deputy Commissioner has consistently replied as follows: that the land of 0.70 hectares under survey number 14 by P was mutated in the joint names of Anjana Devi and 30 others.
Because the petitioners are part of this 14 persons jointly.
That is the repetition. The difference establishment.
So out of these 14 persons, 4 of the petitioners, appellants before this court. Yes.
The land question with full knowledge of the petitioners and no objection was ever raised. Reference is made to section 162C of Andaman Nicobar Islands Land Revenue and Land Reforms Regulation 1966 to argue that the right of tenant has been extinguished under clause C when a part of such land has been transferred or been let out to use in contravention of the regulation. Next, it is also contended that the petitioners did not take steps to reclaim the land on which the road was constructed by the MES. Admittedly, the petitioners are not claiming the land on which the road was constructed. They only claim the remaining areas of 0.70 hectares of land which remains outside the scope of the road construction.
But this was under joint possession of 14 persons.
Because only the road was constructed. The next single judge has heard in law by observing that the petitioners are not claiming the land on which the road was constructed. Petitioners are claiming the land on which road was constructed.
On 0.70 hectares road was constructed. That is your case.
They are claiming this particular land, 0.70 hectares.
Of land which remains outside the scope of road construction, there you have objection. Then
There, it is their case that they are claiming the 0.70 hectares of land where the road has been constructed by MES.
so the only claim, the remaining areas of 0.70 hectares of land which remains outside the scope of the road construction, that is incorrect according to you. Because the road was constructed in 0.70. So what happened to rest of the land?
Other person in 1977.
Yes, please present
The land was never acquired by the administration.
yes.
Therefore, normally follow that the possession of the land comprising 0.70 hectares must either be returned to the petitioners or any alternative land of 0.70 hectares must be made available to the petitioners by the administration and or the MES. MES is not the party to the process.
It's a what is the full form of MES?
This is a different entity, not. It doesn't come under the administration.
Just a minute, just a minute. So this land of 0.70 was never acquired. So then how MES constructed a road on that land without acquisition?
Before 1977, when the petitioner's father, he sold out the property excluding this 0.70 hectares and occupancy right also.
What has happened to that property which was sold to third party? That person.
0.70 hectares, which was never claimed by the predecessor in 1977. When he sold this property, he has excluded that portion. Only the remaining portion he sold out. And he never raised any objection before the authorities that look, my land has been acquired by the MES and they have constructed the road. Never.
No, whether any whether a doctrine of waiver or acquiescence which you trying to indicate will wipe out their property right. Now, what you want to say that they have never claimed, so they have waived, so their title right, title interest will go.
Constructed on this 0.70 hectares land, and the rest part was already. So, or according to the suite MES,
You are in control of the total land.
unless until you acquire.
You acquire. So you declare that MIC is a forceful occupier.
Okay, the recorded tenant has never been objection to the authority that 0.70 hectares of land are in possession of MES at the time of sale of that particular land, At the time also, he did not raise any objections and excluding that 0.70, rest of the land he has sold out.
No. So for the rest of the land, that is 2.01 or 2.11.
Yes.
That land has been sold to third party. Now, according to you, this 0.70 hectares remains. What is your case in the appeal is that on this piece of land of 0.70 hectares, road was constructed for MES or by MES. Now, question arises that this 0.70 hectares of land must have been acquired without acquisition. How this road was constructed? Because the land department or the appellant, they should have acted as an acquisitioning authority for acquisition of this land.
Objection that my land has been acquired by MES or one road has been constructed, even they don't.
No, that has not been acquired.
But from 77, your case is from 77 to 2015, there was no demur by the writ petitioners.
These writ petitions.
They are 13 in numbers. They are 14 in numbers. Because 0.70 were recorded in the name of.
Asking the petitioner's father. The legal heirs, I think 11.
So at that material point of time, no steps were taken against the acquisition of this land. But that land is to be acquisitioned following the procedure. So what procedure you have taken?
Understand.
Okay, the fact remains.
They have made this approach rule. And we have never given any no objection, or they have taken permission, nothing is there.
Nothing was there. So according to you, MES should be made party, should have been made party.
On this permission, made,
How they got the right to construct road over this piece 0.70 hectares of land.
We are saying.
Now, what is the rest of the order? Let us see in view of the Deputy Commissioner. The Deputy Commissioner has gone on record on 6 occasions that the land was never acquired by the administration. So it is your case that it was not so according to it was not never acquired. Then
Either to return to the petitioners or any alternative land of 0.70 hectares must be available to the petitioner by the administration and or the MES. MES is not made as a party to the proceeding.
or an alternative.
In view of the above, this court directs the Secretary Revenue of the Municipal Administration to take a decision in the matter, that is either to return the possession of the 0.70 hectares of the land to the petitioners or provide them with alternative land of equal value and location within a period of 3 months from the date of publication of this order. The road constructed by the MES shall not be disturbed by the administration or claimed by the petitioners. The petitioners may be heard formally by the Secretary Revenue, and the land proposed to be offered to the petitioners shall be indicated to them in writing. The Secretary Revenue shall also consider a choice of land comprising of 0.70 hectares that may be requested by the petitioners for being returned to them. It is reiterated that the land to the extent of 0.70 hectares must be of equal value, location, and importance. The order of the Deputy Commissioner.
The Secretary Revenue shall also consider a choice of land comprising must. Now, Mr. Jaipal, one thing is also troubling us, that come to paragraph 9 of this order under challenge. It would therefore, the second line, it would therefore normally follow that the possession of the land comprising 0.70 hectares must either be returned to the petitioners or any alternative land of 0.70 hectares must be made available to the petitioners by the administration and or MES. MES was not party to the to this writ petition.
For the first time, I have approved this code during the year 2015. Till now, this 0.70 acres is in my name. We have been paying revenue to the appellant's hearing, but the property was taken. Not there are 8.
Property was taken in 1977.
In this 6th round of litigation, those orders they never challenged.
No. Only thing is this today, which is troubling us, that if it is a direction for returning 0.70 hectares to the petitioners, to the petitioner by administration or MES, then if MES is not party to the petition, how this order is to be carried out?
2018 writ petition and that has been turned down. They are not challenging that.
But the court has said that it is to be returned by the administration or MES.
But see the first line of paragraph 9, the deputy commissioner has gone record on 6 occasions. Same order 6 times passed, order set aside. Same order, which have challenged the writ petition. That the land.
Now, if the case is this, that in the stay petition, they have stated, just a minute,
That papers it's not made part of the case, but
just a minute, that total piece of land was 3.11 hectares, out of which 2.41 hectares was sold to only available area measuring 2.41 hectares to one PK Govindan Nair. That was sold. So the rest of the land was 0.070 hectares. So the road must have been constructed on that land. Because other than was sold to PK Govindan Nair, and to the extent that so if the road was constructed on the piece of land measuring 0.700 hectares, then where is the scope of returning the land?
one thing at page 3, God would see paragraph 11. The road constructed by MAC shall not be disturbed by the administration.
Yes.
The road would remain.
Then if road would remain on 0.70 hectares, on where is your road? Because in the affidavit,
These issues have already been decided in the 6th round. They never challenged.
see, either you have to stay the order and file a paperwork, but appropriate course will be to remand the matter to the learned single judge, and MES should be made party, and the writ petition to be heard again.
Application. It's not that for the first time the writ petition was moved.
But the opposition was exchanged in connection with the writ petition.
Yes.
So what opposition will file?
Hearing the order in which the challenge for the 6th time is the part of the opposition. 6th time.
But even then, if the even appeal has to be heard without hearing MES. Without hearing MES, appeal is to be heard. Then, according to the respondents, land department, there was no formal acquisition proceeding. Now, question comes up, Mr. Jaipal, the question in that even comes up, then how MES has utilized this land if there was no acquisition? So therefore, MES has to be heard.
Actually, fact as on date, fact remains is that land has been utilized. Either you or MES, you not in a position to return the land. So the remedy is to
Because it's-
either Miss Das, please, yeah. Either you have to make an alternative land available for him, or you have to pay compensation as per the act. So you decide. Now MAC would be treated as a requiring body. You take up the issue with MAC. Either we have to make party MAC here, or you take up the issue with MAC. In a return cannot be possible. That is the modified order.
Not either returning or give alternative. I'm
Return.
concerned with alternatives. And so
Order.
only the road has not been disturbed.
But
The report
MES
said
was
the road
referred
is
to
not-
on what basis they got the right to, because they were the requisitioning authority. So if
This
MES was
should be as a requiring body.
requiring
Requiring
so on
body,
what basis they got the right? But today, if we admit the appeal and directing paperwork, then without hearing MES, that appeal is to be heard. There is a difficulty.
But I'm
So
just fine.
on what basis MES got the right?
MES
should
can be added as a party.
But in that event, the MES would lose one forum. Because the matter should be remanded back to the learned single judge for re-hearing after MES to be added as party respondent.
So, opposition, but for 6-7 times before this court, but kindly appreciate the property is recorded in my name.
First position has been
All
taken
these 6 orders, identical order was never challenged of this
before
court.
97, my lord.
Never challenged.
1977. The right has been created, adverse possession right has been created.
No, that adverse person right, that is not.
Possession right.
That is not, Miss Das. Either you have to, here Land Acquisition Act is applicable. So either you have to pay money, and now under 2013 Act. Or you have to make available one alternative land of equal value such and such for the.
I know the property, they are saying, they are property, like I identify as a lawyer, I know my laws, there are properties located.
So pay compensation, pay compensation.
Value need to look
Actor means one of the.
at older area.
Protection the stakeholder. কিন্তু MES কে against যে party right করাটা কি করবে?
সেইটাই।
সেটাই কারণ তো movement তো MES was not a party.
হুম।
So on what basis MES got the authority to utilize the land? That is very important.
The issue in between the administration and MESC.
Right. So they are saying they are
Actually,
saying-
MESC done the wrong. MESC issue a request.
Item number 10. WPA 3 of 2022.
My lord had asked us to take instructions regarding the point which Mr. Kabir had raised.
That
Optic fiber. So my lord, I have to be on the safe side, my lord, I have got written instructions from both the PBMC and the APW.
ये PBM के वो नीचे वाला है
I'm just placing that, my lord.
स्टार्ट
First, my lord, I'm placing the report of the APW. In any event, we were required to file.
ये जी संविधान का रेजिग्नेशन नहीं निकाला इसे फाइल करवाता है So you have obtained instructions.
That is the written instruction. In any event, my lord, I'm also handing over the instruction from PBMC. Honor. But my submission is, my lord, in any case, my lord, we have to file it in part of the with a report by way of affidavit. So this is the written instruction that has been received. But we have to file it by way of affidavit in any case by end of February, my lord.
So you have time up to February.
Yes, sir. So
Yes, Mr. Kabir and Mr. Kumar. They have time to file a report.
They have a time to file a report with regard to repair of the road. Now, with all respect to everyone concerned, may I say this? I raised these observations with regard to the damage as a special officer of the court.
While laying cable beneath, along the
Along the
road.
sides of the road that
Along
is
the road.
damaged. I know this is not an adversarial litigation because if it was, I would ask that this be filed on affidavit so that perjury action could be taken.
The report which is to be.
We are as special officers of the court, we have a responsibility only to the court, to no one else. Page 2, the work carried out by telecommunications companies are at present completed and the dugout holes are covered by concrete and no holes are left open is a completely misleading and incorrect statement. Today morning I have seen. Now I have filed a report with photographs showing it. I have no personal interest in this litigation. I am merely an officer of the court. So I don't know what to say.
Incorrect instruction. Today we can say it's an incorrect instruction.
No, I would prefer then because I have placed a report with photographs. Therefore, I am a person who cannot really say.
And you are regularly using these roads.
No, but
So every.
unfortunately discuss and aspersion on what I have said. So I wonder whether I'm neutral as a special officer or I should just step back. Let someone else make an inspection and see whether.
No, we will not allow you to.
This is
step back.
absolutely ridiculous. Today morning I have driven and come.
No, this is in parts, my lords. It doesn't refer to all the portions.
No, let it come in the form of the report.
The second paragraph of page 2 says.
Indicating.
Other thing.
So that court can be made aware of the
Yes,
facts, what is there.
Only see the second last paragraph. As of now, there is no traffic issue owing to damage of roads. I wish that these officers who have worked with us, the APWD officers have worked with us along the NH stretch with Mr. Binnu and myself for months now. Let one of them come with me on an inspection. Let there be an inspection
In
order.
any case,
I'll do it.
in
There
any.
should be a joint
No,
inspection.
That's what we've been doing all this time. Now
In any
these
case-
statements are absurd and that is my submission Personally, I have filed a report after placing photographs. These are absurd statements.
In any case, my lord, my suggestion is, my lord, for your lordship's
And
consideration.
whether today on the basis of this in this instruction, this court cannot proceed.
First of all, this sort of report is something we are permitted to file as officers of the court. If anyone else wants to place something on record,
Mr. Kavi, being the, and Mr. Kumar, being the joint special officer, the effort of the court in this matter is to see that the entire work should be completed as early as
Yes, that's all.
to complete the.
But that does not mean that statements should be made, which are incorrect statements.
Kindly see the last order. Your lordships did not direct us to file either an affidavit or a report. That will come by end of February. Your lordship only.
No, there was no requirement to give such directions
Yes.
because you had time till February.
Yes.
So my
End of February.
What is Mr. Chakraborty trying to say? That I am making incorrect
I am not
submissions?
making any statement. I am not.
Because then kindly discharge me from this role here and now.
We are directed to get instructions.
I have my own dignity before the court.
I am only to assist the court. It is in written form. I was not
Mr.
required.
Chakraborty should remember he is appearing for his clients. I am not appearing for a client. I have filed a report on my statements. If they are incorrect, I resign as a special officer here and now. Let Mr. Chakraborty defend his clients.
It is not a personal matter. It is purely a written.
Where is the
instruction.
respect of the court's dignity gone?
If it is incorrect, then why not let them file by way of an affidavit, my lord? I am also saying.
I am going to become a party to this proceeding, filing affidavits. What is this?
No, you just.
And it will kindly record I am resigning as a special officer.
No, will not allow it.
I will not have my dignity called into question.
I am saying the same thing which you said.
My lord, I have to, my lord,
Who will file it?
He's saying that they have instruction, let it come in the form of report. We did it today, Mr. These don't get. You are also working for the betterment of the
Exactly.
and
This report is showing me to be making incorrect statements.
So let it come as.
This will not be taken on record today.
Let it not.
Only court has directed the land advocate to inform that what are steps taken.
Have received.
No,
Let them
let them
file it
file
by
it.
way of an affidavit.
Let them file an affidavit to this regard. This may not be taken on record.
Yes.
I am not asking, I was only assisting the court and the learned special officers. Let them file by way, anyway, they have to file an affidavit by end of February. So, my lord, let it be included in the affidavit, which is to be filed by end of February. Then, my lord, if any wrong statements are made, my lord, it will be open for everyone to assist the court, my lord. That will increase the responsibility also the officer who's giving the affidavit if there are any apprehensions on that count.
Please take it away.
My lord, of course.
Record on.
my lord, I appear on behalf of NHIDCL. Today I have no submissions to make, my lord. My lord will kindly record my appearance, my lord.
It will be recorded. In terms of the order dated 27 January 2025. In written instructions are placed before this court. And on perusal of those written instructions and taking note of the submissions made by the joint special officers disputing the contents of such written instructions. This court expresses dissatisfaction. Next paragraph. However, Mr. Chakraborty learned senior advocate representing administration, representing the administration submits that these are mere written instructions that should not be given credence. And a final, why?
No, I would not say that, then I wouldn't have.
Submits that this is mere written instruction should not be given credence as stuck it off. These are mere written instructions, but administration has time till end of February to file a report in the form of affidavit in terms of the order passed by the coordinate bench. Dated coordinate bench on 7 January 2025. Stop. Next paragraph. let such report be filed let such report be filed in terms of the order dated 17 January 2025 by February 2025 by end of February 2025. Stop. List the matter.
One request, my lord.
On 3rd March 2025 for further consideration. Next paragraph. Written instructions which are placed before this court are returned back returned back to the learned advocate representing the administration. Since contents of this instruction, written instruction return back from.
One
Let
request.
him come up with a.
My lord, only one submission I have to make because lordship, my lord, this matter is made returnable on every circuit.
Just one thing, just to assist the court, my lord, so that there is, my lord, where your lordship has said that it was recorded my submission, that my lord, we have time till end of this thing to file a report. My lord may only add, this is only to, even in view of what has been submitted by the learned special officer, including on this aspect. Because my lord, because this aspect was raised in view of the observations of the learned special officer. So my lord, including on this aspect may be added, my lord, because that will also be covered in the report. So where my
Which aspect?
this on which the written instruction was given, because my lord has returned this, and since this is disputed, so we have to cover this in the report as well. But my lord, if my lord just says, when my lord is recording my, if it comments to your lordship that a report has to be filed by end of February, and this will include this aspect, because otherwise, my lord, this was called for in view of what was submitted by the learned special officer. The report was more general in nature. So I don't want tomorrow that, if this aspect is not covered, it shouldn't be that, my lord, that we are misleading the court or doing, trying to avoid any issue in any manner.
And also addressing the issue raised by the.
And the report shall also disclose the steps taken by APWD and PBMC for repairing the road and filling up of holes created for cable laying. Stop.
Most great.
But I'm sorry, I apologize
Record this.
for my outburst.
No. The issue is very.
I will not have my integrity called in.
Sumoto.
If your
So
lordship,
this, the court wants to see that the work must complete.
that
And
is true.
and one of the cars of our court got damaged when it went to Diglipur. Few months back.
But I should also.
This is the position, Mr. Chakraborty. So use your good office and.
My lord, only, my lord, one submission, my lord, this matter is returnable on every circuit.
Kabir indicated that due to cable laying work, there's the roads in and around the town, which comes
Yes.
under the jurisdiction of PBMC as well as APWD, got damaged. So in addition, there are two court wants a report from you that should be a comprehensive report.
Yes.
That apart from the highways, what are the steps which are being taken to complete the repairing work and filling up of holes?
The concerned officer responsible person will file an affidavit.
Very, since you have time, you are in a position to take steps accordingly.
Yes, my lord.
Yes.
My lord, there is a direction that this matter is returnable on every circuit, my lord, because NHIDCL has to file a report. My lord's pleasure was to fix it on 3rd March.
Of every circuit.
No, but since up to February 2020, up
So
to
the next circuit, it has to come in the first week.
very
of the
well,
next-
very well.
As per the.
First week of every circuit. Then it will be on,
Purpose will be.
it will be on 10th March.
Yes.
It will be on 10th March instead of 3rd March. That will be the last day of that
The next
circuit.
circuit, I believe, is from the 17th of February.
But in the meantime,
My lord, no purpose will be served unnecessarily. Why should be served? What your lordship has said.
same, there will be no alteration of situation in the meantime.
My lord.
Since the coordinate bench is directed to file report by end of February.
So my lord will indicate NHIDCL will also file their report on 10th March because my lord there is a direction upon us to file it on the returnable date. So my lord for us also let it be there.
NHDCL shall also file a report before the next date of hearing.
Grateful, my lord.
I'm sorry, my lord, I apologize.
Yes, yes. But don't quit. It's a matter which requires
Doesn't have.
certain steps to be taken.
Then.
Yes, yes, yes. Yes, next matter. 14. Done. 11.
Oh, acha.
My lord, this is that matter, my lord, where this arises out of compensation, the Workmen's Compensation Act, my lord. And my lord, that there were two respondents.
We will come back on Monday.
No, my lord. Labor Commissioner, let it be next circuit.
No, let it be on Monday. If you entrust your junior, let us see. Monday.
Okay, Monday.
Let it be on Monday. Come back.
Monday, what is the date?
Come back on Monday. Yes, 14.
14.
Monday. Monday.
This is a hearing matter, my lord. 14.
Let it be on Monday. We'll see. We'll see.
Item number 15. WPCT 19 of 2024.
Monday.
Well.
Mr. C.
Number two.
Blind. Next. All the list. Item number one.
My lord, I am for the petitioner. 16 December order may be seen, my lord.
And I am for respond number two.
Number one.
One.
For respond number two, my lord, I am seeking extension of time to file.
My lord, 4 weeks time was granted, 8 weeks over.
Stephen, add another line. The matter stands released. Previous matter, yes, matter stands released. Yes, order dated 16 December 2024.
Yes.
Petitioner pays for review.
4 weeks time was granted, 8 weeks over. I mentioned the matter, now they are praying for.
Last opportunity may be
You have to
given.
mention the matter for hearing in the next paragraph. As a last chance, file your affidavit by 2 weeks.
My lord.
If matter has come up in the list under the heading to be mentioned, on being under the heading to be mentioned, quote unquote, to be mentioned, capital, on being mentioned by the learned advocate representing the petitioner. Next paragraph. It is today it is submitted on behalf of the petitioner. The time which has been fixed by the coordinate bench, video order dated 16 December 2024 for filing affidavit in opposition has expired. Stop. Next paragraph. Learned advocate representing which respondent?
Respond number two.
And you don't want to file an affidavit.
Pilot is granting time, if we have to file.
Learned advocates represent what I was telling. Yes. Learned advocates representing respondents have jointly prayed for extension of time to file affidavit in opposition. Stop. Next paragraph. As a last chance, time to file affidavit in opposition stands extended by 2 weeks. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks. Reply
1 week.
by 1 week thereafter. Next paragraph. List the matter under the heading hearing before the next available circuit after the time fixed herein above for filing affidavits on extension.
Highly obliged.
Obliged.
Next.
Number two. WPS budgetary sub 935.
Lordship, I am appealing for the petitioner. There was direction given upon the petitioner to add the private respondent and serve notice. Notice was served, but notice was not able to serve because the private respondent has not received the notice unserved.
Just a minute.
There was
Hey, switch off this AC.
simply add the name directly. I'm correct. क्या दे दीजिए ना
You could not serve notice of
Notice of
private
difference.
respondent.
Your Honor, Lordship, my simple where is that let my application can dispose of
How it can be?
opportunity can given to the both the parties. That can, that direction can be,
Since court has passed an order directing you to serve notice, you have to serve.
yes.
Land advocate representing the petitioner prays for accommodation to serve notice upon additional respondent number 5 or upon respondent number 5. Stop. However, administration is represented by land advocate. Next paragraph. Time to file. Next paragraph. Land advocate for the petitioner is directed to serve notice upon respondent number 5 by 10 days from date and file affidavit of service on the next date. List the matter under the same heading before the next available circuit after the time fixed herein above for effecting service of notice upon respondent number 5. Next.
Number 3, WPS 63 of 2025.
I appeal on behalf of the respondent.
Yes.
I'm appearing on
All the
behalf of
respondents are represented.
My
My lord, the issue is that, my lord, I am running a crusher unit in terms of the permission accorded by the authorities. Now, my lord, on the premises that I have extracted beyond the capacity or illegally, straight away passed an order whereby directed me to pay a sum of rupees 4,90,000.
Yes, please repeat it again.
My lord, on the allegation that I have carried illegal mining, they directed me to deposit an amount of rupees 4,90,000. That notice was never served upon me. Final order was passed without giving an opportunity of giving. Now they say that in the event you did not pay the said amount, we will recover it in terms of the land revenue regulation, my lord. Now, after that order, subsequently they pass an order saying that since you have not deposited the amount, therefore we are closing your mining unit. No opportunity was given. At no point of time any opportunity was given. I paid the said amount. I paid the entire amount.
When?
The day when the order was passed, subsequent order was passed on 8th January, which was communicated.
8th January 2025.
2025, communicated to me on 9th January 2025.
Yes. Now.
9th January itself, I have paid the entire amount in their account and said that it is without prejudice to my right to challenge it. Page 39. Despite of that, I was not allowed to run my.
Yes. Yes. Since it has been paid.
My lord.
Paid without prejudice to my right. Now, my lord, I have challenged this order on further.
Whether you are eligible to get the recovery, that will be decided on affidavit. But in the meantime, permit the petitioner to run the mining unit.
Yes.
Since it has been paid, where is the page 39?
Page 39.
My lord, let this matter be fixed on Monday, my lord. In the meantime, I will take instruction.
My lord, I have served long back, my lord, and DD number and all, DD receipt is also there, part of the writ petition at page 41.
Yes, and the check is page 41.
Page 41. Yes, my lord. Now, my lord, there is no reason, my lord.
There are not today. Not today. Take
I'll
instruction.
take instruction and come back on Monday.
Only thing is this, that petitioner will seek recovery of that amount.
Yes.
But that will be decided on affidavit.
Yes.
But in the meantime, since payment is made, permit the petitioner to run the unit without prejudice to the rights and contention of the parties. Yes, next.
Item number 5, WPS 65 of 2025.
Yes.
Lord, I appear on behalf of the respondent.
Petitioner, she was the encroacher of 1978 legalization scheme came, and thereafter the license was issued in the year 1989. Though license was issued in the year
1989. Pre-1978 encroacher.
There was a scheme, as per the scheme, she was entitled to 350 square meter, but she was encroached only 300 square meter. She got license for the 300 square meter. Thereafter, my lord, it is representation, but the premium has not accepted and the record has not been done. Once the
This,
license is given, my lord, the authority has.
Any document in support of the license which is annexed to the writ petition?
It's at page, my lord, 11. Page 12, page 16 is the license. 16, my lord.
Yes. Now, what is your grievance?
Clause 6 says, my lord, the premium has to be determined by the authority. It has not done, my lord.
So you want determination of premium?
Premium, thereafter, my lord, the license has to, the record has to be corrected by giving the record.
What is your prayer application?
My lord, my prayer is at page 8, my lord.
Page 8.
My lord. I've made representation from.
Where is your
Representation,
application?
my lord.
Yes.
17, my lord, page 17.
17.
17, 18, 19 and 20. For representation.
Deputy Commissioner is the authority.
My lord.
Yes, Ms. Das, let it be
My lord.
decided by the Deputy Commissioner for determination of premium as well as and what are the other
Finalization of the
sees
record.
license,
correction of record.
correction of record.
Yes.
The license, the first clause, my lord, may kindly come to page 16, my lord, license.
Yes, page 16. I am on page 16.
First, the licensee shall construct a house on the said land within 2 years from the date of issue of license. The licensee shall, whether, my lord, these.
It was granted on 22nd August 1989.
1989, my lord.
Whether.
But till date, no house has been constructed.
This is there, my lord, whether, because.
So we will take decision. Take decision on this.
Hello.
Why court will decide this issue at this stage when the administrative authority has not taken any decision?
Hello.
By presenting this writ petition, prayer is made for determination of premium which is required to be paid by the petitioner in support of granting license in respect of a land under plot number 33/12, measuring 300 square meters, situates at Prothrapur, Port Blair. What are the other one is determination of premium and another.
And the tenancy has to be created, my lord.
Yes.
In the revenue records.
Petitioner has also prayed for correction of record. Correction of record.
No, record has not yet been prepared, my lord, because after the license, once the premium is accepted, my lord, then the tenancy has to be created. The record entry and sketch
So
map.
the first step is determination of premium.
Premium.
Let it be decided.
My lord,
First, let it be decided.
my lord, if it is not mentioned, my lord, then I have to come once again for the tenancy.
Stop. Stop. It is also submitted by the learned advocate representing the petitioner that on determination of premium, consequential steps are required to be taken. By the authority. it is further submitted that an application has been made on 25th March 2011 before the Deputy Commissioner South Andaman, Port Blair, before the Deputy Commissioner South Andaman, being respondent number
2, my lord.
2, seeking determination of premium, and the same is kept pending. Next paragraph. Administration is represented by learned advocate. Next paragraph. Having considered the submissions made on behalf of the parties and taking note of the license granted by the authority on or with effect from 1st August 1989, which is at page 16 of the writ petition.
Second.
2nd August 1918, which is at page 16 of the writ petition, comma, the writ petition stands disposed of, directing Deputy Commissioner South Andaman, being respondent number 2, to take decision on the representation of the petitioner dated 25th March 2011 by 8 weeks from the date of communication of this order after granting opportunity of hearing to the petitioner or her representative. Stop. Respondent number 2 is required to pass a reasoned order and same is to be communicated to the petitioner by 10 days thereafter. Urgent Xerox certificate copy.
Applied, my lord.
Next.
Item number 6, WP 8 of 2025.
My lord, I am appearing for the department. I am assisted by Mr. Ayanava Raha and Mr. Anindya Khanna.
Yes.
On the last occasion, my lord has regularized my appointment, but they have appointed some other senior advocate. Calcutta.
Yes.
Yes, my lords, I'm advocate Arupdas Gupta. I'm appearing on behalf of SN Tiwari. Our main two submissions are, my lord, that these are notices which have been issued under section 73 of the GST Act, while the orders have been issued at a mixture of 74 and 73. So 73 is for non-fraud matters, my lord.
Issued under section 73.
Yes, my lord. If I may kindly request my lord to go to page 33. Sorry, page 30, my lord. Page 30 of my petition.
Page 30.
Yes, my lord. So, my lord, it reads intimation of liability under section 73(5).
Yes.
While the order has been passed, my lord, under section 74.
Under section
74.
Not under section 73.
No, not under section 73.
This is your grievance.
This is my first grievance, my lord, that this cannot be order under 74
So
because my initial intimation was under 73.
Where is the order?
And my order has been passed under 74.
Where is
and
the
again,
so
my lord,
contention is that the notice was passed under section 73.
yes, initial intimation was passed under 73. Yes, my lord.
70 under section
73.
Yes, and the order was passed under which section?
74.
Was passed under 74.
70. My lord, preliminary one thing. My lord.
A minute, Mr. Kundalia. Wait.
Yeah.
Yes.
My lord, yeah. My second submission regarding section 74 is, if I may read section 74, it says determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud or willful misstatement or suppression of facts.
Please give me the book.
Yes, my lord.
Where is the book? From where you are reading?
My lord, I'm reading from the Act only, section 74.
GST.
CGST Act, my lord.
74 is determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud or any willful misstatement
Statement or suppression.
of
Facts. Facts. But here, my lord, my main thing is that the one of the main category allegation against me is that I violated section 16(4), which is I have availed the ITC after the due date for availment. But the very fact that I have availed the ITC after the due date of availment, that is within the knowledge of the department, because I have already filed the 3B. So it is nothing that I have suppressed it from the department. It's only relevant.
Please elaborate. Please elaborate.
My lords, if I may take my lord to section 16(4), my lord, in the same CGST Act.
74.
No, sir. No, my lord. Section 16(4).
16(4).
4, yes, my lords.
Yes, 16(4).
My lord, it reads that a registered person shall be entitled to take input tax credit in respect of an invoice or debit note for supply of goods on both, service of both, after the 30th day of November, following the end of the financial year to which such invoice or debit note pertains, or furnishing of the relevant annual return, which was the earlier. So in this case, what I have done a violation by availing the credit.
Yes, yes.
Yes. So, my lords, here it is said that if I am not availing the credit within 30th day of November, at that time it's a different time, I cannot avail the credit. But when I'm availing the credit in GSTR 3B, which is the form for availing the credit, it is well within the knowledge of the department that I've availed this credit beyond the time limitation. So there is no suppression on my part, my lords. Because 16(4), they have brought out the allegation on their own facts, on their own documents. I have not appended any further document. So if the facts and the documents are with the department, how can the allegation of suppression be brought against me? That is my second submission, my lord. So the element of 74 does not arise at all. So this is my second submission, my lord.
Now, there's a notice at page 30.
Yes, my lord.
On the point that since the notice was issued under section 73, so the order cannot be passed under section 74.
No, my lord, that cannot be passed.
This is your first point.
This is my first point, my lord.
So where is the order under section 74?
Yes, my lord. My lord, if I go to page 39 of the petition, my lord.
That's from 34.
Yeah, page 34 of the petition, my lord. Yes, my lord.
But the second paragraph says any persons aggrieved by this order may file an appeal against this order in section 107.
That is what I was coming to preliminary.
No, my lord, a order cannot have both section 74 and 73 together. Because if you see, my lord, in the last page, in page 43 of the order.
7, Mr. Dasgupta.
Yes, my lord.
It is an appealable order under section 107 of CGST Act.
Yes, my lords.
So why you have not preferred appeal?
Yes, because there is another ground of violation of principle of natural justice.
But,
the email ID to which actually I have come to the Honorable High Court because of two reasons.
Where there is an effective, efficacious alternative remedy is available. Why,
yes, my lord.
Why you will skip that opportunity?
My lord, there are two reasons for doing that, my lord. First, there is exercise of wrong jurisdiction. Because when a notice has been issued under 73 and an order has been issued under 74.
Provision, you aware of this provision, and then you, if you are, then.
My lord, if you can kindly bear with me for two minutes, my lord. My lord, I request you to bear with me. My lord, the notices that have been sent, they have been sent to the wrong email ID. That is not my email ID only, my lord. I have not got the notices. So there is a gross violation of principle of natural justice. So our only humble prayer is, my lord, if the matter could be given remanded back to the adjudicating authority, we will furnish all the documents before the adjudicating authority so that the adjudicating authority is satisfied.
Yes, Mr. Kundilia.
My lord will kindly see the first point I'm dealing with. He is saying that he has not got notices.
Yes.
My lord, the first point I'm dealing with is, my lord, I am audible, my lord?
Yes, you are audible.
The first point I'm dealing with is that he says that he has not got notice. Now, my lord will kindly see his pleadings. My lord will kindly come to paragraph 11. Paragraph 11 of his writ petition.
Yes.
Which is at page 7. My lord, he has himself, if my lord sees, he says there, copy of the said show cause notice dated 1 September 23 and form GST DRC 1 dated 28/7/23 are annexed herewith. Now he has said this and he has not annexed the show cause notice here. What he is showing, my lord, is only the form GST DRC 01. The show cause notice is different, which has been encapsulated in the order.
Just a minute, let me go through the statements made in paragraph 11.
Paragraph 11. He says, may I place that paragraph 11, my lord? Your petitioner states that thereafter respondent number 1 initiated proceedings against the petitioner under section 73 of the GST Act by issuing a intimation in respect of the alleged short payment of tax or excess settlement of ITC in form DRC 01A dated 28/7/23 and thereafter show cause notice dated so and so after asking the petitioner as to why as an amount of 21,28,330 should not be demanded from the petitioner on account of interest and penalty.
The short payment of tax and excess or / excess availment of ITC in the DRC 01A dated 28 July 2023 and show cause notice was within the knowledge of the petitioner.
Yes, and my lord, my lord will now kindly take the GST Act.
Is there any time specified in the
my lord will kindly take my lord will kindly take the GST Act one. My lord will kindly turn to section 169(1), subsection 1. 169. Has my lord got it?
Yes.
Now my lord will kindly see 169(1). Any decision, my lord, may I place this section? Any decision, order, summons, notice, or other communication under this act or the rules made thereunder shall be served by any of the following methods, namely, now my lord will straight away come to C. Apart from the normal registered post and all that, C, by sending a communication to his email address provided at the time of registration or as amended from time to time, or by making it available on the common portal. So minute, my lord, an order is passed, it is uploaded on the common portal. When it appears on the common portal, it is a correct mode of service. That apart, he has been also sent the email.
Cannot be edited, but there was insufficient notice.
He says that. But
yes,
169(1).
Now, what the query of the court is the appeal which is required to be taken out in in terms of section 107. That is there any limitation?
Yes, there is a limitation.
Yes, there is a limitation, my lord.
My lord, there is a limitation period of 90 days.
Come to section 107.
Yes, my
Yes,
lord.
my lord.
My lord, 3 months is a time
Yes.
that is prescribed in 107 subsection 1 from the date on which the said decision or order is communicated to such person. He obviously has the copy of the order. He
No, my
doesn't
lord.
challenge. He doesn't challenge. He hasn't challenged that he has not got a copy of the order.
In which subsection period of limitation is prescribed under section 107?
107 subclause 1, my lord. Any person aggrieved by any decision or order passed under this act or the state goods and service tax or the union territory goods and service tax by an adjudicating authority may appeal to such appellate authority as may prescribed within 3 months from the date on which the said decision or order is communicated to such person.
When this order was passed?
My lord will kindly see page 34. 7th December 2023. 7th December 2023. Today, because he has not been able to file an appeal, he has lost his time. He
No, my
comes
lord.
straight away
My
before
lord.
the writ petition. Now, after all, more than 1 year, 1 month.
My lord, it may also be appreciated that my registration was suspended. I was not regularly visiting the
No,
portal.
registration suspension was much later.
No, my lord. No, my lord. It is on
Yeah,
January
post
23.
2023.
January 23. My lord,
Yes.
it is January 23.
But that has
And the order has been passed in 7th December.
If the is on upon condoning delay, if the appeal is preferred, appeal is considered by the authority.
My lord, if my lord deems it fit to pass such an order, then will not take it officially from me, but my lord.
Let me grant liberty to the petitioner to file an appeal under section 107 within a period of fortnight from date. If the period of fortnight such appeal is preferred, then without taking the point of delay, the appeal is to be decided by the authority. Yes, Mr. Dasgupta.
My lord, we were requesting for a remand of the order to the adjudicating authority as the Honorable GST Council has actually given a waiver for section 16(4). So if it will go to the adjudicating authority, our demand of section 16(4) could be dropped by the learned adjudicating authority.
No, that even for that, my lord, even for the submission that my learned friend is making, for that there is a circular.
Please allow me to pass an order.
Okay, my lords. Oblige.
By presenting this writ petition, comma, inter alia, comma, challenge has been thrown to the order dated 7th December 2023. By the superintendent within bracket range 3 close bracket Andaman and Nicobar division, Haldia, CGST and CX commissionerate.
My lord, if you permit, may I say one small submission, my lord?
It has been agitated by the learned advocate representing the petitioner while questioning the validity of the impugned order dated 7 December 2023, that though notice was issued under section 73 of the
My lord, that show cause notice has not been annexed.
And Services Tax Act 2017. But order was passed under section 74. But the order was passed, yes, unmute.
Yes, my lords. Yes, my
Order
lord.
was passed under section 74.
My lord, the Arbitration Authority has considered both section 74 and 73 together.
Under section,
Yes.
Under section 73 and section 74.
Yes. Because my lord, show cause notice has not been annexed. Show
2017.
cause notice is very clear.
But
Stop. The manner of serving notice upon the petitioner is also questioned in this writ petition. Stop. However, on perusal of the relevant provisions of Central Goods and Services Tax Act 2017, it appears that under section 107, there is a provision to prefer an appeal against any decision or order passed under the said Act of 2017. Stop. Next paragraph. In view of availability of efficacious alternative remedy, this court grants leave to the petitioner to prefer an appeal under section 107 against the order dated 7 December 2023 by fortnight from date. Stop. If appeal is preferred against the aforesaid time, the appellate authority, without raising the issue of limitation, shall decide the same on merit in accordance with law. Stop. Next paragraph. Hence, the writ petition stands disposed of. Before the penultimate direction and part regarding preferring an appeal, record one more line. Mr. Kundoliya Lanet, senior advocate, representing the respondents, has disputed the contention of the petitioner that notice disputes the contention of the petitioner that show cause notice was not appropriately served upon the petitioner. Upon placing
Section 169. 69(1).
relying on section 169 of the said act. Stop. Urgent Xerox certificate copy.
Grateful, my lord.
Yes.
My lord, our appearances have been given in the chat box, my lord.
Yes. Yes.
Me and my juniors, my lord.
You
Grateful.
by fortnight.
yes, yes, my lords.
The issue relating to limitation appeal to be heard on merit.
Okay. Oblige, my lord.
এটা দিয়ে দিবে সঙ্গে রাখবে। Yes, next matter.
Item number 7, WPS 60 of 2025.
The application is pending, Lordship.
Say similar order. Well, let us see. Where is your application?
Page number 11.
This application dated 5th September 2024. So application date 5th September 2024. 5th September 2024 application date, and assistant engineer is respondent number 3. Disposed of. Pass on. Pass order accordingly. Let's see. Next.
Item number 8,
Same Lord.
WPS 66 of 2025. Page number 18 of 21, sir.
What is the date of your application? 5 December 2024. Respondent number 2, assistant engineer. Disposed of. Obliged, Lord. Next.
Item number 9, WPA 163 of 2024 with CAN 2 of 2025.
I am appealing for the writ petition. My lord, this is an application, my lord, seeking extension of time for implementing the order path.
Yes, prefer this application.
My lord, on behalf of the High Court administration, my lord. Learned Registrar General has affirmed the affidavit since.
You are seeking extension of time for the petitioner. Let me go through the order. At page 4 of of your application.
Yes, my lord. The issue, my lord, the writ petition.
Just.
My lord.
When 6 weeks has expired,
My lord, this is an order dated 3rd of December, my lord. There is a,
it has expired.
it has expired.
So what is the present position? Whether the,
It has been-
whether paragraph 8 directions as contained in paragraph 8 of the order has been complied with? Learned Register Circuit Bench was directed to forward the prayer of the
It has
petitioner.
been forwarded, my lord. It has reached the office of the learned registrar
When?
general. I've stated so in my application. It reached, my lord, on 5th December 2024.
Which paragraph?
Second paragraph, my lord. Thereafter, it was placed before the Honorable Chief Justice, my lord,
So received the office of the.
and the
Just a minute, just a minute.
and paragraph 4, my lord, the Honorable Chief Justice has directed it to be placed before the committee, my lord, the
December.
Recruitment and Promotion Committee.
5th December, registrar principal bench has received it.
My lord.
Yes. Then,
My lord, then it was placed before the Honorable Chief Justice, my lord. The Honorable Chief Justice had directed it to be placed before the Honorable Recruitment and Promotion Committee, my lord. It has been gone. Now the committee has to assemble and take a decision, my lord. It's at the final stage. He is seeking basically, my lord, a relaxation of his age for considering him
relaxation of age.
age. My lord, the post of Deputy Registrar protocol has fallen vacant, my lord.
Here.
Here, my lord. And this gentleman, my lord, who is holding the post of Superintendent, Office Superintendent, is eligible but does not possess the qualifying services, my lord. So he's seeking a relaxation of his age, my lord. So since the
So how much time is required?
6 weeks, my lord.
Another 6 weeks.
I've been instructed to ask for 6 weeks.
Already by 17th January, the time period was expired.
We will take decision by 6 weeks. Already the steps have been taken in terms of the direction as contained in paragraph 8.
My lord.
So therefore, High Court administration should take decision by 6 weeks.
Right.
Yes, Mr. Kumar, do you have any objection?
Objection, my lord, but my lord will find in para 9, it says positively within period of 6 weeks. Now, if my lord is extending, let it be positively within that period.
The application being can 1 of 2025 is taken out. By the High Court administration. Or by the administration of High Court at Calcutta, including the Registrar Circuit Bench of Calcutta High Court at Port Blair, seeking extension of time as fixed by a coordinate bench in the order dated 3rd December 2024. To take decision on the prayer of the writ petitioner for promotion to the post of Deputy Registrar within bracket protocol in the Circuit Bench of High Court at Calcutta in Port Blair. At Port Blair. Stop. Next paragraph. Learned advocate representing the applicants submits that in terms of the direction of the coordinate bench, the prayer of the writ petitioner was forwarded to the Registrar General High Court at Calcutta, and same was received on 5th December 2024. And steps are being taken to place the prayer, place the same before the appropriate committee for taking decision. Stop. It is submitted that in order to complete the entire process, further time is required. Next paragraph. Writ petitioner is represented by learned advocate who has submitted that steps are required to be taken immediately. Since time fixed by the coordinate bench in the order dated 3rd December 2024 has expired. Stop. Next paragraph. Having considered the submissions made on behalf of the parties, application being Can 1 of 2024 is disposed of, extending the time for a period of 4 weeks to complete the process of taking decision on the prayer of the writ petitioner seeking promotion. Urgent Xerox certificate copy.
Let it be 5 minutes, my lord. My lord knows the assembling of the committee, it becomes difficult in Calcutta, my lord. My brother will not object to it.
The difficulty is that if my lord sees.
Well, 5 weeks.
Oblige.
Next.
Item number 10, AP 14 of 2024.
Lordship, twice I have served upon the respondent, twice I file affidavit service as per direction, but none appears. This is application under section 11(6) for appointment of an arbitrator. Because if private parties make a clause in the agreement, any dispute, arbitrator is to be appointed. I give notice to him, he refused to appoint arbitrator. Prior to this, section 9 application was before the learned district judge who passed an order protecting the interest.
Serve another notice and come back. Since
Certainly.
nobody is represented today.
As you know.
When you have served last?
Lastly, I served
Late.
second affidavit.
Show me that the service is complete.
It was 22nd January, intimating him that matter will appear on 3rd February.
How you have served by registered
By
post?
registered post and for postal track report indicate that 25th January he received it. By which he was asked to appear on 3rd of February 2025.
Record an order. In spite of service of notice, on 25th January 2025, opposite party is not represented today. Stop. For abundant caution, learned advocate, no, abundant caution, strike it off. Learned advocate for the petitioner is directed to serve another notice upon the opposite party, enclosing copy of this order by 10 days from date, and file an affidavit of service, file further affidavit of service on the next date. Next paragraph. However, it is made clear if in spite of service, opposite party is not represented on the next date, the application shall be decided in absence of the opposite party. Next paragraph. List the matter under the same heading on February 2025, subject to convenience of the bench. Next,
Item number 11, CPL 5 of 125.
But here, Chief Justice, again, you know, Raji has passed the contempt petition. Just to be placed.
page, but there is an order of the court of the Honorable Division Bench.
From the
Order has been affirmed. Justice Mukherjee passed order on page 10. Contempt proceeding has arisen out of the order dated 24 June 2024, passed by the Honorable Justice Ajay Kumar Mukherjee. So, next paragraph, let the records of this contempt proceeding be transmitted immediately to the principal bench and be placed before the Honorable Justice Ajay Kumar Mukherjee. Next, registry is directed to take necessary steps. Next,
CPL 6 of 125.
but here, this is Rajashekar Mukherjee.
Justice Mantha.
Page 10 only. Okay.
Same order. Justice Rajashekar Mantha. And date is 13 November 2024. Next,
30, CPL 7 of 125.
Here, Justice Partha Sathi. It will dated 18/11/2024.
Justice Parthasarathi Sen, order dated 18th November 2024. You have to move the bench at the principal seat. Yes, next.
Number 14 of the 49.
Once it was written as per the instruction of the petition. So it is in the same building, still the office is not due. Once again, I send to speak.
So you want to serve upon which respondent? Respondent number? Does that matter? Which one?
That's the main respondent.
Still the office is functioning.
Land advocate representing the petitioner has prayed for accommodation to effect service of notice upon respondent numbers 4, 5, and 6. Stop. Let such notices be served upon upon respondent numbers 4, 5, and 6 by 10 days from date. List the matter under the same heading. After the time fixed herein above for effecting service of notice upon respondent numbers 4, 5, and 6. Other respond, you are representing which respondents? Administration is represented by administration is represented by land advocates. Next,
Number 15, WPA 3 and 4 of 2022. So kind of opposition.
You are for the petitioner. This is 16, item was 16. 15, divisional forest officer. Land advocate representing respondent has prayed for extension of time to file affidavit in opposition. Time to file affidavit in opposition stands extended by 2 weeks. Next paragraph lists the matter under the same heading before the next available circuit after the time fixed herein above for filing affidavit in opposition. Next.
Item number 16, WPA 19 of 2024.
For better, as your lordship indicated, I have to place whether the proceeding can be initiated against a retired person.
On the submission of the land and the petitioners and respondent with the matter. You are required to obtain instruction in this matter.
Here, my lord, the petitioner sought disciplinary proceedings against the private respondent. Disciplinary proceedings were carried out, and the private respondent was acquitted of the charges. But the petitioner has filed a writ petition stating that the wrong authority carried out the disciplinary proceedings. But during the pendency of the writ petition, my lord, the private respondent has retired. So now, my lord, according to us, according to the state respondent and perhaps the private respondent, the writ petition, the cause of action.
You are representing private respondent.
My lord, that proceeding was culminated on 31st of August 2017. Thereby exonerated me from all the charges.
Who is he? Who is the petitioner?
He was not an employee. He was not a whistleblower. He was working in the same department.
No. My complete inquiry was initiated.
My lord, let me place the fact first. After 2017, my lord, the order was passed in 2017. He chose to challenge it in 2023 by filing a writ petition. No reason at all.
No, you are not suffering due to pendency of the writ
I am
petition.
not suffering, but
You have received all benefits after exoneration. So let it be before the next circuit. As paid for by the land advocate representing the petitioner, list the matter under the same heading before the next circuit. Whistleblower, you are the whistleblower. Very well, next matter.
Item number 17, WPA 93 of. I am appealing for the writ petition.
Yes.
It is a contract matter, my lord, and taken up if other parties are ready.
Where is Miss Nag? Where is she? Next circuit. List the matter before the next circuit.
First, my lord, it's a contract matter, already 1.5 years past.
Record an order. At the time of call, respondent numbers 1 and 3 are not, at the time of call, accommodation has been prayed for on behalf of respondent numbers 1 and 3. However, petitioners and respondent number 2 are represented by learned advocates. Next paragraph lists the matter under the same heading before the next circuit. Next.
My lord, my request there was for demarcation of my landed property recorded in my.
Where is your affidavit in reply? You have filed. Record an order. In terms of the previous order, affidavit in reply has been filed by the petitioner, by the petitioners. Next paragraph. List the matter before the next available circuit under the same heading. Yes.
Item number 19, WPA 273 of 24 with 2021.
One similar. But I served upon the added responsibility. Commissioner of Fisheries at Chennai. I served notice on 16/9/24. But the original postal receipt is with my client is out of India. So I am unable to file the affidavit of service.
You are for the petitioners.
I am for the petitioner.
And for respondent number 5.
Which again I will issue notice upon the commissioner, madam. And I will file affidavit.
Land advocate representing the petitioners has prayed for accommodation to effect service of notice upon respondent number 7 afresh. Stop. Next paragraph. Respondents are represented by learned advocates. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon respondent number 7 by 10 days from date and file affidavit of service on the next date. List the matter before the next available circuit. Next.
Item number 22, WPA 30 of 2024 with item number 23.
I'm appearing for the respondent, my lord.
Your Lordship, my senior advocate Angelina appears on behalf of the petitioner, Your Lordship.
Not today.
Let both the matters be on next circuit, Your Lordship. For item number 23, we require some time to file the reply.
23.
Yes, sir.
This is
Analogous matter. Analogous matter. 22.
22 and 23. So in item number 23, you are praying for time to file affidavit in reply. On behalf of the petitioner in WPA 314 of 2024, prayer is made to extend time to file affidavit in reply. Stop. Let such affidavit in reply be filed by 2 weeks from date. Stop. List the matter before the next available circuit after the time fixed herein above for filing affidavit in reply. Matters. There are 2 petitions. You have to transcribe, yes, indicating 2 petitions. Yes.
Okay.
Yes, next.
Item number 24. 42 of 2024.
Next circuit.
You are for the petitioner. As prayed for on behalf of the petitioner, list the matter before the next circuit.
Item number 25, WPA 425.
25 to 28, let these matters retain its position in the list on Monday.
28 maybe next circuit.
Very well, I'll see to that. Let it be on Monday.
Which is the next matter.
Yes.
Then perhaps go to the next circuit.
So it will be considered on Monday.
I'm not there on Monday. My lord.